get your attention, please?
Hi, my name is Wes Nickman. I'm co-president of the American Constitution Society, and we are co-sponsoring this event with the Federalist Society, and the president right there, Dan Hartman, will speak right after I do. Just like to welcome you all for coming out this evening. Hope that you learn a lot from this and that you guys get some good tasty treats up there. Just going to read a couple lines about the American Constitution Society here. The American Constitution Society, ACS, believes that law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues through development and promotion of high-impact ideas to opinion leaders and the media by building networks of lawyers, law students, judges, and policymakers dedicated to those ideas. All right. And coming up right now is Dan Hartman, President of the Federalist Society.
I've got a quick blurb I got to read about the Federalist Society as well. I'm not going to use a microphone. My name is Daniel Hartman, and thank you all for coming tonight. On behalf of our chapter, I just want to welcome you to tonight's debate, Admissions and Race, the Future of Affirmative Action in Higher Education. Of course, Mr. Larry Purdy and Mr. Thomas Saenz. Our moderator will be Dean Oliveri. The Federalist Society is a conservative libertarian organization dedicated to fostering free, fair, and open debate on the fundamental principles of freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs like these, literature like we have out on the table, on how limited constitutional government based on the rule of law can promote good policy and law. Our moderator this evening is Dean Rigel Oliveri. Dean Oliveri served as trial attorney with the U.S. Department of Justice, practicing in the Civil Rights Division and Housing and Civil Enforcement section. Her published work has appeared in the Stanford Law Review, the Harvard Civil Rights Civil Liberties Law Review, and the Vanderbilt Law Review, among many others. Dean Oliveri is the Associate Dean for Faculty Research and Development and Associate Professor of Law. She teaches fair housing, employment discrimination, civil procedure, and pretrial litigation. Please welcome Dean Oliveri.
Thank you. Thanks to everyone for being here, and thanks to ACS and the Federalist Society for putting on this very important debate on a very important topic. I'm going to introduce the speakers, and I'm going to let them take it away. And then when we're finished with the debate itself, we'll have time for questions. First, Larry Purdy is an attorney with Edelman, Foreman, and Brand in Minneapolis, Minnesota. 9 years ago, Mr. Purdy served as pro bono trial counsel for the plaintiffs in two landmark U.S. Supreme Court cases, Grutter v. Bollinger and Gratz v. Bollinger. Both involved the University of Michigan's overtly race-conscious admissions policies. As a consequence of his involvement in these cases, he has been frequently invited to discuss the role of race in college and university admissions at law schools and colleges across the country. In addition, he has addressed numerous local, state, and federal bar associations on the topic of race. He's the author of the amicus brief filed in Fisher v. University of Texas on behalf of Congressman Allen B. West. Mr. Purdy is a graduate of the U.S. Naval Academy, and he received his J.D. from the William Mitchell College of Law in St. Paul, Minnesota. Our second speaker, Thomas A. Saenz, is the president and general counsel of MALDEF, where he leads the civil rights organization's 5 offices in pursuing litigation, policy advocacy, and community education to promote the civil rights of Latinos living in the United States. Mr. Saenz rejoined MALDEF in August of 2009 after spending 4 years on Los Angeles Mayor Antonio Villaraigosa's executive team as counsel to the mayor. Prior to that, he spent 12 years at MALDEF practicing civil rights law as a staff attorney, regional counsel, and vice president of litigation. He served as MALDEF's lead counsel in successfully challenging California's anti-immigration immigrant Proposition 187. Mr. Saenz graduated from Yale College and Yale Law School, and he clerked for 2 federal judges before initially joining MALDEF in 1993. So please join me in welcoming our speakers, and then we'll begin.
Well, Dean Oliveri and Mr. Saenz, students, faculty, and friends of the University of Missouri, it's a distinct privilege to be here tonight to discuss what I think remains one of the fundamentally most important issues we deal with here in this country, and it's the issue of the role that race is going to play, and that race does play in the important decisions that impact all of us. And I think that they impact our families, our friends, our colleagues, our co-workers, my children, my grandchildren. Important decisions about who's going to get a particular job, and in particular who may get a letter of admission or a letter of rejection from our nation's flagship universities, like this great university here in Columbia. The fundamental question, of course, is what role, if any, race should play in these decisions. And that was the precise issue I dealt with for 7 years in the University of Michigan cases, which involved a challenge to two separate admissions policies, one operated by the undergraduate campus, and one a very different, but also heavily race-conscious policy that was operated by the University of Michigan Law School. The justification that Michigan offered for using race in admissions was the university's claimed compelling interest in enrolling a racially diverse student body. And it's this rationale, together with the methods that have been adopted by other universities, including the University of Texas at Austin, that is now back before our highest court in Fisher. You might ask, what was my baseline starting point when I first got involved in these cases back in 1997? And it was this, assuming I can get the right, there we go. Okay. I'm not going to read these slides to you. I'm going to let you take a look at them. I'm trying to make them fairly brief, but the quote you see here is from a second unanimous decision in Brown versus Board of Education. And I will tell you that in my opinion, this was the greatest case ever decided by our Supreme Court. It established a principle that, to me, says all we need to know about the role race should play in public education. And the answer is absolutely none. The sentence starting point for my involvement can be found in the language of Title VI of the Civil Rights Act of 1964. And again, I don't need to read it to you, but it's very simple and straightforward. They're pretty clear words to me. They remain, at least on paper, the law of the land. And yet this language has come under severe challenge, initially with the positions taken by Michigan in the case back in 2003, and again by the University of Texas in the current Fisher case. As it turned out, the Supreme Court in 2003 struck down Michigan's undergraduate policy in favor of my client, Jennifer Gratz. They did it on a vote of 6-3. But in Grutter, the law school case, the court upheld a policy that was even more heavily dependent on race. And the only difference between the two, if you read the opinions, and I assume that many of you may have read the opinions, is what Justice Souter and Justice Ginsburg both characterized as a much better hidden system under the law school system. The use of race was actually had a much heavier impact in that system. Like it was upheld and the undergraduate system struck down. And in the opinion that was written by Justice O'Connor was born the diversity doctrine, which currently permits schools to use race as a factor in deciding who receives an offer of admission or a letter of rejection. Now, before I go any further, let me tell you two things the Michigan cases were not about, and this extends to Fisher as well. First, the Michigan cases were not about criticizing the general concept of diversity. And second, the cases were not about dismantling affirmative action programs. First, with regard to diversity, I take what I hope we can all agree is a non-controversial position. Each individual is unique. As a consequence, anytime there's more than a single person in a room, the group is diverse. Every individual sitting here this evening adds diversity to this group. You add diversity to your law school community, to your university, to our country. And this is true even if some of us share certain immutable characteristics such as the skin tone or hair color, eye shape, body type, height, weight, gender. None of our clients in the Michigan cases ever argued that diversity itself was a bad thing. On the contrary, we acknowledge that all sorts of diversity can be a good thing and provide educational benefits to the students. But we also said this: no matter how beneficial diversity might be, no school can justify using racially discriminatory admissions policies to achieve it. Now let me also briefly mention affirmative action. Nothing you will hear me say tonight is designed to dismantle affirmative action plans. I'm a proponent of affirmative action. I always have been. Properly defined, affirmative action has nothing to do with race. Quite the contrary, affirmative action plans were intended to eliminate race as an obstacle to equal opportunity. Now for a little history lesson. Most Americans are completely unaware that the phrase affirmative action was first coined by President John F. Kennedy in a 1961 executive order. Here are a few of the more relevant phrases. Again, I won't read them, I'll just let you take a look at them. And then we get to the next part, and I've underlined the phrase affirmative action, and you can see that what it says is the contractor will take affirmative action to ensure that applicants are employed and employees are treated during employment without regard to their race, creed, color, or national origin. President Kennedy's directive was clearly to remove race, not add it as a factor in these government decisions. And it was an expression of, consistent with his expression of our national policy of non-discrimination. No less an advocate for equality and equal opportunity than a former chairman of the Joint Chiefs said it best, but he's not alone. But let's take a look at his words. If affirmative action means programs that provide equal opportunity, then I'm all for it. If it leads to preferential treatment, I'm opposed. The Army, as a matter of fairness, made sure that performance would be the only measure of advancement. General Colin Powell, in his 1995 autobiography after he had left public service and before he actually returned to continue to serve the country. Here's another statement. My dad told me one thing when he came back from World War II. We all wear green, we all bleed red. There's no difference, and don't let ethnicity play a role. Major General Alfredo Valenzuela, testimony before the Military Leadership Diversity Commission given January 14, 2010, not that long ago, and I'll comment more about this Diversity Commission in a moment. What's important to note here is that the arguments of General Powell and Major General Valenzuela are founded upon the same bedrock principles argued by Thurgood Marshall in Brown versus Board of Education. In Brown, when he was serving as one of the counsel for the plaintiffs, Thurgood Marshall demanded that the Supreme Court enter a decree commanding the Topeka Board of Education to, and I quote, discontinue the practice of using race or color as a criterion for admission of students to the public schools. Thankfully, he and his colleagues succeeded. In my humble opinion, his words to the court are as relevant today as they were when he first penned them back in the early 1950s as part of the briefing at Brown. To me, that was what the Michigan cases were all about. Or that's what they should have been about, reaffirming the principle adopted in Brown over a half century ago, that racial discrimination in public education is unconstitutional. Sadly, however, the court of Grutter refused to adhere to the principle established. In fact, 5 justices of Grutter deviated so horribly from it that we're now firmly back to a situation in this country where race officially matters. Think about that. Race matters. That, of course, was the claim of the old line of segregationists, a concept I thought was put to bed decades ago, but I was wrong. In the battles moved a very different playing field. Rather than equal opportunity irrespective of color or ethnicity, which has been our society's goal for more than a half century, we have reverted to an openly race-conscious concept that's been relabeled as an interest in diversity. Now, with this introduction, let me return home here to Columbia and review the equal opportunity affirmative action policies that are probably featured on this university's website. The first one, and note, it's actually combined, equal opportunity / affirmative action policy. And it makes clear that the university is going to recruit and employ qualified personnel, provide equal opportunities without regard to race, color, or national origin. All this, of course, is perfectly consistent with President Kennedy's initial use of the phrase affirmative action, and to all that I say amen. Here's a very recent statement that I found, just posted a little more than a month ago, 2 months ago. Statement of non-discrimination. And what's important here is that it makes clear the university is committed to not discriminating on the basis of race or color, and it makes reference to Title VI of the Civil Rights Act of 1964, which we just reviewed. Very clear. And here's the third one. University of Missouri Civil Rights Policy has the same language about employment decisions being based only on valid job requirements. Race has no part in the decisions, very first line. Not to belabor the obvious, but there's nary a word anywhere in any of these statements suggesting that Missouri is committed to anything other than a strict policy that prohibits racial discrimination on this campus, and an equally strict policy that guarantees every person within this university equal opportunity without regard to race, color, or national origin. That's the way, exactly the way it ought to be. For nothing else is clear. This one thing should be clear. When it comes to judging the value and the worth of our fellow citizens, race should never matter. Earlier, I included a slide that had Major General Valenzuela's testimony about ethnicity. You'll recall it was given, I said it, roughly 2 years ago at this Military Leadership Diversity Commission. Sadly, if the drafters of the policy coming out of that commission, which have relied heavily on the ruling in Grutter, have their way, and if their policy recommendations end up being adopted, the day when race won't matter may never come. And let's look at just one of the many questionable observations found in this commission report. Again, read it, and I've outlined it. And to me, this is language that is stunning in 2010. 2011, actually, this is when it was issued, just a year ago. Although good diversity management rests on a foundation of fair treatment, it is not about treating everyone the same. And then they go on to essentially demean the idea of people who have grown up with the equal opportunity inspired mandate to be colorblind. And it begs these questions. The mandate is to treat everyone fairly. How does it translate into not treating everyone the same? For example, what would be fair? Why would it be fair? How could it be fair to treat an individual applicant for seat, say the class of 2016, differently from one another because of his or her skin color? Why would the traditional equal opportunity inspired mandate to be colorblind no longer be the preferred model? And again, these are just questions that I pose, and maybe we can discuss them later. And in the end, are the most successful leaders the men and women who do in fact create a culture of assimilation within their respective organization in which racial differences are rendered completely irrelevant? Isn't that what the EO mandate, is that what it was sought, it meant to achieve, and isn't that what Title VI of the Civil Rights Act of 1964 requires? I want to wrap up quickly, turn away from the military for a moment, talk about a little less lethal example. I want to preface this part of my discussion by saying that I used to dislike resorting to athletic analogies, but I've changed my mind. They're often destructive and something most of us can relate to. So, a year ago, I'm a Navy veteran, and a Naval Academy graduate. And I spent my time in the service. A year ago on Veterans Day, November 11, 2011, the United States Navy hosted a unique event. It was a college basketball game staged on the flight deck of the USS Carl Vinson. It was billed as the first carrier classic, and it featured teams from two of the premier college basketball powers. I'd love to put Missouri in that. Maybe Missouri will be there someday. These happen to be Michigan State University and the University of North Carolina, Chapel Hill. Obviously, both of these universities are among the great universities in the country. It's worth noting that few, if any, representatives of these two universities receive more public attention than do their elite Division I basketball team. For most people outside their respective campuses and even on the respective campuses, the face of these two universities is perhaps best represented by the faces of these talented student athletes. So when the teams took to the floor on the Carl Vinson, there were a couple things one might have noticed. The first, obvious in my mind, the most obvious, was that 5 players wore green and white. 5 players wore Carolina blue. Second observation, which may have gone entirely unnoticed in this day and age, would have been this. Of the 10 starting players, and I'm going to make a generalization here based on race, 9 were young men who might have self-identified themselves from a racial standpoint as black, and 1 was white. To the best of my knowledge, there wasn't a single Hispanic or Native American or Asian among them. So did Michigan State's team racially reflect the university it was representing? Did it reflect the state it represented? Or the city of East Lansing, Michigan, the home of Michigan State University? Same question for the kids from University of North Carolina, Chapel Hill. Of course, in my view, if you were wearing the camo-tinged green and white uniforms of Michigan State, you were a proud Michigan State Spartan. If you were wearing Carolina blue uniforms, you were a proud Tar Heel. Your race didn't matter one bit. Every week, the field house in East Lansing during basketball season and the field house in Chapel Hill are filled with fans who come to cheer their team on. Fans of all races and genders. Do you think anyone in either field house is concerned that in some form or fashion, the racial composition of the team does not reflect the racial demographic of the university or the state? And if there are a few outliers who actually do care, does that mean that we should care? How are these players chosen to start this carrier class? I think it's pretty simple again. Standards are pretty straightforward. If coaches are doing their job, the same standards apply to each young man on both of these teams, irrespective of his race or his ethnicity. Nothing other than their merit as basketball players, which includes a large dose of character in order to be a great player at the term of their selection as starters. Are these young men diverse? Well, in my mind, they are, because each is a unique individual. Each of them deserves our respect, and more importantly, each deserves equal treatment and equal opportunity measured against the same set of standards, regardless of the immutable factor of their skin color or ethnicity, whatever it may be. Race, this immutable factor, tells us nothing about a person's talent, skills, honor, courage, intelligence, or his dedication to any task. To paraphrase Dr. King, a man's skin color tells us nothing, absolutely nothing about the content of his character. Was Dr. King right? I believe he was. And as for the colors that matter here in Missouri, in my view, there are only 2 you should care about, black and gold. The rest make absolutely no difference. And that's the simple message I hope the court and Fisher opts to embrace. I look forward to taking questions. Thank you.
Good evening. Thank you all for being here tonight. I think that the issue that we are discussing, like Mr. Purdy, I believe is one of the most critical legal issues that we face. Now, I should say, because I believe, as you'll learn in greater detail, in the importance of context, that we should note that we are having this debate somewhat prematurely if one were to read the decision in Grutter, and in particular to read Justice O'Connor's assertion that this issue should be settled for 25 years. Instead, less than 10 years later, a changed Supreme Court has taken up the case of Fisher versus University of Texas. In that way, thrusting upon the country a renewed debate about equal opportunity in university admissions, and specifically what role, limited by the Supreme Court's previous guidance in the Michigan cases, what role race ought to be allowed to play in making those decisions. I think it's also important to note the context of the particular case that the Supreme Court chose to hear. It comes out of Texas, second largest state, a state that I have some familiarity with because MALDEF, my organization, was founded in San Antonio, Texas, some 44 years ago. We've maintained an office there ever since, and throughout our nearly half-century of history, we have expended a great amount of effort in trying to ensure that the state of Texas arrives at a more fair and equity-inducing educational system from kindergarten all the way through the university. It's important to understand the population of Texas. The 2010 census tells us that 38% of Texans are Latino. 38%. Now, because the Latino population tends to be younger than other populations on average, it is an even higher percentage, a higher proportion of those under 18. Specifically, half of public school students in Texas are Latino. And that means half of the pool from which the University of Texas chooses its class are Latino. And despite those population demographic statistics, the University of Texas, using the top 10% plan that I'll describe for you, those of you who are not familiar with it in a moment, and using a supplemental whole person evaluation system for the remaining 15 to 20% of the class, the University of Texas enrolled 23% of its freshman class as Latino. 50% of public school students, but 23% of those admitted to the University of Texas. That is important context when you look at the case the Supreme Court will shortly decide upon. It's also important to note that in this case, even the plaintiff, Fisher, in her brief to the Supreme Court, notes, and indeed this is part of her argument for why race ought not be considered at all, but concedes that at best, 2 to 3% of the class of the University of Texas may have been admitted based on race. At best, race may have made a difference in who was admitted with respect to 2 to 3% of the university's freshman class. Also, important context. It may occur to some of you, why are we having a debate about a program that at best determines the outcome of 2 to 3% of admissions to the University of Texas? And I think you've heard from Mr. Purdy as good an explication of what has been characterized as a color blindness perspective as you can hear. And that basically is the issue from the perspective of those challenging a program that has such a minimal impact. Their perspective is that the law ought to be, quote unquote, colorblind. The problem, again, is one of context. Now, those of you who are lawyers, and even those of you who are law students, even the first years, who are at the very, very beginnings of your long and illustrious careers, have no doubt already concluded that our legal system is often quite incapable of taking into consideration relevant context. Our legal system tends to blind itself from relevant social, historical context in making decisions. And I believe that this particular area of equal opportunity admissions programs is one area where, in particular, our Supreme Court has proven itself largely incapable of considering all of the context surrounding these decisions. Let's discuss some of what is not considered, at least as the Supreme Court's jurisprudence in this area has developed so far. I think it's important to begin by asking, what is the purpose of a public university? Now, in this day and age, we sometimes have come to believe that this is really about rewarding those who have succeeded in a competition with a plum seat in a premier university. And in fact, from the perspective of the 17-year-old, and perhaps that 17-year-old's parents or grandparents, certainly that is an understandable perspective on the purpose of a public university. But in fact, public universities exist and are funded by the general public, regardless of whether the taxpayer or taxpayers have children who have any opportunity to go to that university. They all fund public universities to create leadership, to create a well-educated and trained workforce for the future. In other words, to serve the interests of the entire state. Not to reward in competition particular individuals or their parents with a plum seat in a premier university. When we recall the public purpose of universities, the demographic facts that I just described with respect to Texas take on more importance. The University of Texas is designed, in theory, to serve the entire state of Texas, 38% of which is Latino. Now let's look at the nation as a whole, because of course, while the Supreme Court will render a decision in a case against the University of Texas, its decision, unless it ends up not setting a precedent, its decision will have an effect on the entire nation. The demographics today of our public school students nationwide. As of 2006, 1 in 5 public elementary and secondary students in this country is Latino. 16% of public elementary and secondary school students in the entire nation are African American. Together, that means that 36%, well over a third, of all public elementary and secondary school students in this nation today are African American or Latino. Projections tell us that by the end of this decade, 1 in 4 public school students, elementary and secondary level in this country, will be Latino. 16% will still be African American, meaning that 41% of our students in elementary and secondary school in this entire nation will be African American or Latino. Those are important facts when you consider, once again, the purpose of public universities. Consider also the fact that we still have, and no one would deny, we still have an educational achievement gap of significance between African American and Latino students and white and Asian American students. Whether you look at college-going rates, test scores, test performance, dropout rates, there are still significant, statistically significant and pronounced gaps for these communities. That too is important context in looking at and evaluating equal opportunity admissions programs. Now you may ask yourself, why does that gap persist? And I would tell you that a large part of the explanation for that continuing educational achievement gap are continued inequities in our school system. Right now, this week, I have a team of lawyers in Texas who are, for the 4th time, challenging the state of Texas and its system of providing resources to public schools, such that it still, after 3 previous challenges, has a system that benefits largely white, suburban, property wealthy districts over heavily minority, inner city and rural, property poor districts, such that there are pronounced differences in the educational experiences received by students based on where they go to school. That has to also be taken into consideration as relevant context with respect to equal opportunity admissions programs. A second critical set of contextual considerations is to ask yourself, what is the purpose of an admissions process to a premier university, a premier public university? Should we be looking to reward students and their parents for what they have been able to learn, regardless of the context in which they learned it? Are we looking for the students who at the age of 17 have been able, through resources made available to them, to achieve to the highest level as traditionally measured? Or should we be looking for those students with the greatest potential to take the university education to which they are being admitted and succeed with it? To go as far as possible in their professions, to become as accomplished as possible in serving the state and the nation. If you accept, as I think most admissions officers would, most university officials would, that there's precious little to reward at the age of 17, and that in fact what we are doing is evaluating potential for future achievement. And if you agree that it is about potential, then there are serious questions that become relevant context around the admissions tools that are currently used. The simple fact is that we have no way of comparing from district to district in the state of Texas, for example. Because one district has many more resources, many more opportunities for every one of its students than another. So a grade of an A in a class in one district is not the equivalent of an A in the exact same class in another district. No question. So how do you evaluate potential in that context? And when we look for standardized measures, measures to standardize our evaluation between districts where conceitedly opportunities and resources are different, the tools we have come up with are woefully inadequate. Standardized tests still correlate highly with income more than anything, are still predictive only of the first year of performance, and still show pronounced disparate impacts, pronounced racially linked differences in performance. This tells you, if you choose to interpret this context, I think logically, that our existing admission systems are incapable of using the tools currently at their disposal to evaluate fully the potential of every applicant. With those inadequate tools, with the purpose of the admissions process in mind, with the purpose of public universities in mind, the question has to become, should we still consider race as relevant context in evaluating the potential of students applying for admission? And if what I've established so far doesn't suggest an answer, let me go further. Just this week, the Associated Press released polling data that told us that in fact in our society, regardless of what the law may want to say, in our society in 2012, race still matters. What the Associated Press told us is that still a majority of Americans carry negative attitudes about African Americans when measured from explicit indications, and an even higher majority, 56%, carry negative impressions of African Americans when measured from an implicit analysis. Similar numbers for Latinos. 52% measured explicitly have negative opinions about Latinos. 57% measuring implicit bias have negative attitudes toward Latinos. Race still matters in this country. That too is a relevant contextual fact. Now, it is indeed possible to decide that all of that context, no matter how relevant and logical it may seem, should be ignored in service of a colorblindness principle. But the question before the court is, should the University of Texas be allowed to consider race in this limited context? I've already mentioned that 80% of students are admitted to the University of Texas based on the top 10% plan, a conceitedly race-neutral program that admits students based on where they were ranked in their own high school. Only 15 to 20% of the class is filled using a whole person evaluation, looking at all of the facts about the applicant. And in that context, one fact that is considered is race. So the question before the court is, should that kind of limited consideration of race be allowed in a whole person review admissions process? If you look at all of this context, I think the answer has to be yes, so long as race still matters in our society, in our social, historical context. It still must matter in evaluating individual people's potential, individual students' potential to take a university education and succeed. I agree with Mr. Purdy in this regard. I too believe that every applicant should be treated the same. But my definition of the same means that every applicant should be evaluated for their potential in full consideration of the context in which they come to the university. That includes where they went to school, the resources and opportunities made available to them. That includes their parents' educational background. That includes income. But so long as race still matters in this country, that full context still includes limited consideration of the importance of race in the development, in the measurement of the potential of any university student. Thank you.
Let me try and be brief about it. Mr. Saenz addresses a lot of issues, some of which I completely agree with. I agree with about the problems with the achievement gap. The cure is not to use different standards based on race. Shelby Steele, I don't know if many of you are familiar with him, but he wrote a book called The Dream Deferred. And he said the demeaning and condescending thing you can do to a person is to lower a standard based on his or her race. The only way you show true confidence and respect for this person is to give them the compliment of holding them to the same high standard. And when they achieve at that high standard, then there's nothing more to be said about inequality. So using different standards of admission, which is inevitably what they do, when race is a factor, that's what happens. You're lowering the standard. It's demeaning and condescending. And I think, in fact, there's an awful lot of research that's come out. I'm going to mention a book that was published the day before the oral arguments, in fact, by two men who are not opponents of race preferences. Richard Sander, UCLA law professor, Stuart Taylor, a lawyer and journalist, neither of whom share my principled objection to the use of race. They don't share my objection at all. Their only question is, do preferences work? And they say they don't. They do more harm and terrible harm to the purported beneficiaries of these policies. If you're really interested in seeing whether or not these should be compelling interests using race in admissions, go get a copy of Sanders and Taylor's book. It's entitled Mismatch. I agree with Mr. Saenz when he talked about socioeconomics and class issues, and that these are the things that should be considered when you are looking at students who are applying for admission. Maybe their SATs aren't as good. Maybe their grade points weren't as good. Maybe their high school curriculum wasn't as strenuous because of the school that they attended. But you take all that into consideration. That really is more of a class preference. It's a socioeconomic or educational disadvantage preference I absolutely agree. I have no opposition. If I were on an admissions committee and you brought me a student who showed that they had overcome all of the obstacles that Mr. Saenz talked about, I would give that student a great look, and I would not send that student a letter of rejection in favor of some just hypothetical kid who may have got perfect SAT scores and a high grade point at some privileged school, but had nothing else on his or her record to show, to distinguish them. I would pick the kid who actually shows that they've got that ability. But you know what? That's race. That has nothing to do with race. That has nothing to do with race. Let me just tell you, and this is an established fact. If you think that most of the students that got into the University of Michigan Law School because of racial preference came from inner city Detroit, you are terribly mistaken. You are terribly mistaken. Most of these students came from very privileged backgrounds with good educations. That race was the only factor that made the difference. It wasn't reaching out. The university, the undergraduate admissions policy actually had a 20-point bonus for socioeconomic disadvantage that had nothing to do with race, or for educational disadvantage that had nothing to do with race. It also had a 20-point advantage for race if you were one of the underrepresented minorities that they preferred. You couldn't get both of them. So if you got the bonus for race, you weren't socioeconomically deprived. My clients did not oppose using class and socioeconomic disadvantage as a preference. And as I said, if I'm the admissions officer and you bring across my desk the kind of application that Mr. Saenz is talking about, I'm pretty sure I know where my decision would come down. But there are kids of all races and ethnicities who can have those same stories. If the SAT is biased, Mr. Saenz makes a comment about it being biased. My comment is get rid of it. Because if it's particularly if it's shown to be racially biased, it ought to be out. It ought to be to do away with it. The fact of the matter is, all the administrators, including the ones from Michigan, said, "Oh no, we can't do away with that." It's actually the best predictor of your performance in college and law school. There aren't very many good predictors, but undergraduate GPA, the high school GPA is one, or undergraduate GPA is one, and your LSAT scores or your SAT scores are another. Now, are they perfect predictors? No. But the schools won't do away with it. They put that high premium. Michigan wants that high premium on SAT, and they're not, or LSAT. They're not about to reduce it because that's what they get their U.S. News and World Report ranking review when they're number 3 or 4 or 5 or 6. And so, but my view is this: if you're putting too much emphasis on the SAT, or in particular, if you find out that it's biased, I'll join Mr. Saenz right now. We'll take that case because it shouldn't be used. Anything that is biased against any particular racial group or ethnic group should not be used. Let me see. I will just. I have one bottom line, and I've said this every time I've spoken about this. I think that I have ultimate confidence in the ability of young men and women in every community, every racial and ethnic community in this country. And I believe if you show them the confidence of insisting on holding them to the very same high standards, whatever the standards are, that they're going to compete. We will have racially diverse student bodies. You could do away with race tomorrow. Texas is still going to have a racially diverse student body. There may be a reduction initially, a small reduction, very small. Mr. Saenz talked about it. I think he said 2%, which actually I want to make one more comment. It's an interesting comment. They say, oh, it's just 2% of people. I mean, who cares? I mean, it's just such a small percentage. But it's not a small percentage if you're Abigail Fisher, or if you were my client, Barbara Bruder, or if you were my client, Jennifer Gratz. These are individual rights that each of us hold. They're not groupings. And that's why I think that we've got to make the commitment, just as Robert said in the Seattle and Louisville cases, if you want to stop racial discrimination, to stop discriminating on the basis of race. Thank you.
You'll note that I said nothing about lowering any standards. What I said was that we need to have standards that are evaluating everyone in context, because that is fairer than the existing tools, because they do have biases. It's simply demonstrable. Now, it's also true that universities don't want to get rid of these tools because they are, from their perspective, efficient. It is much more efficient to look at a number than to evaluate every applicant in their full context. It takes many more people to do the latter than to do the former. But it's also true that the university want to keep the consideration of race, but Mr. Purdy and others have challenged that. So we ought to be challenging the fact that they want to keep these criteria that don't work. We ought to be challenging them to find more and better standards of evaluating people. But I said nothing about lowering standards. I said the same standards apply to everyone, but making sure that the criteria that we use are evaluating everyone fairly and equitably. With respect to what Professor Sander has written, and he is a longtime opponent of equal opportunity admissions programs. I know this, he is from California. He has spent much of the last decade and longer on a crusade against these kinds of admissions programs. But what he doesn't give is a causation explanation for why it might be quote-unquote demeaning. I would assert to you that there is no way of knowing, but certainly a factor is the way that we have, if you will, put on a pedestal criteria that we know have demonstrable discriminatory effects, that we know have limited, if any, predictive value. It's still true that the SAT and the LSAT do nothing more than predict first-year performance. Last I checked, both law school and universities are substantially longer than 1 year. And it has no predictive value beyond that. So these are not great tools, but we have, as a society, chosen to fetishize them and say that they are the biggest measure of merit. And on the other hand, we demonize minority students because they were evaluated based on what they experienced and got admitted. But I will tell you, as a beneficiary of affirmative action, in my admission to Yale University, I don't feel particularly demeaned by the experience that I got there. I don't feel particularly degraded by the opportunities that I received there, and I think that I've paid back society much more than even the great things that I received there. I'm glad to hear, as I've heard from many in debates like this, that Mr. Purdy is ready to go out and challenge these bias criteria. I wish as many resources from both the legal community and the research community were devoted to that effort, as have been devoted over the years to challenging equal opportunity admissions programs at Michigan, at Texas, at universities across the country. Bottom line, I too believe that we should evaluate everyone the same. But the simple fact is that race still matters. So regardless of equivalent socioeconomic situations, I still would say, given the fact that we still have a society where majorities hold negative views about particular communities, that two equally situated applicants, one white, one African American, from the exact same socioeconomic context, if they have equivalent qualifications as measured from other tests, other tools, I still would say the African American student who grew up in a society where a majority have negative opinions about his race, and that no doubt has affected his development, has greater potential than one with equal or equivalent qualifications measured otherwise in the same socioeconomic category, who has not faced that same phenomenon of a majority of society holding negative views about his or her race.
We have some time for questions. and I'm sure, or comments, I'm sure there will be some. So if you want to raise your hand, I'm happy to bring you this microphone if you want to shout it out, you can do that. Tom Leonard.
My question is it Saenz?
That's right.
Mr. Saenz, both of you mentioned this work by Rick Sander. And the book, I have the book. It was started as a law review article in the Stanford Law Review, which is quite controversial. His position, or the claim is that significant racial preferences, and they are significant, they're not tiebreakers, they're significant generally, result in a mismatch where students end up at schools where they're not getting the proper type of education. And so he says that if you end up having minority students who are consistently in the bottom of the class based on the indicators, they're consistently not getting the sort of teaching that would be best for them. And what he shows in the book, and marshalling a tremendous amount of data, is that students that have exactly the same test scores, you take two students, one who took advantage of racial preferences and went to a really elite school, and one that went to a school that's quite fine, but not the most elite. But the one who's in the middle of the class at the less elite school actually ends up doing better. So they have higher bar passage rates, higher success after, this is law school, but after law school, et cetera. And his point is that these preferences are actually hurting the people that they're supposed to be helping because they result in an educational mismatch. And, I'm sort of reading this for the first time, so you seem very critical of this claim. The data seem to be pretty impressive in the book, and so I'm wondering what you think is wrong with this claim.
Well, let me first start by saying I've not read the book. I can't tell you it's on my top 10 books to read.
Well, maybe you should read it. If you're going to go out and make the claims you're making, you should look at the data.
I appreciate you saying that, but I feel comfortable knowing that Professor Sander went into this with an explanation in mind for what he found. That's a problem with lots of researchers. They go in with a preconceived causation notion in mind. It is also possible that universities perhaps need to adjust the supports that they provide to students so that they can succeed best in those university settings. If we were able, as I know he did not, to study what kinds of supports were made available in these prestigious schools, and if they had been made available, how that might change the outcome, then I think you would see a different indication from the quote-unquote data. That's the problem. I'm not disputing the data. I'm disputing his going in and concluding that that's the cause of the outcome that he measures. And that's the problem. Universities throughout history have had to adjust as their student bodies change over time. Whether that's when coeducation was introduced more broadly, whether that was when, many years ago, some of the barriers to admission for people based on religion or race or otherwise, absolute barriers, were eliminated. Universities had to change the way they delivered their mission. And that's certainly true even today because of technology that universities change. Now, universities have not necessarily changed in response to the admissions programs that they follow. And I do fault the universities for that. You should not have a program that considers race in admissions and then not follow up and make sure that the people that you've admitted are able to succeed. That serves no one. So I'm not suggesting that universities are without fault here. I think I suggested otherwise. There are lots of problems with how they have implemented admissions programs and not changed their education systems in response to a changing student body. Now, I just come to this from the basic perspective that, starting from the beginning, that if you are looking for the greatest potential, the highest potential is going to be relatively evenly distributed among all racial groups. There's not going to be one racial group or two racial groups that have much higher percentages of people with high potential versus other racial groups. That, generally speaking, that high potential is going to be represented in each racial group at about the same percentage. That doesn't mean that based on what they've experienced to date up to age 17, some of the inequality in education that I've described, that you don't then have to adjust to make sure that you are serving all of those high potential students well so that they can succeed. That's the mission of the university, particularly a public university, as I've explained. The mission of the public university is to create leaders and educated workforce for the entire state. Now, doing that means, in a perfect world, you want to get all of those high potential students in all racial groups. But it also means that you have to put in place the right programs where you know that some of those students are going to come having experienced unequal opportunities to age 17 or whenever it is, and you've got to adjust for that. There's no question but that universities have to change the way they go about successfully educating if they want to reach the high potential students in every racial group. There's absolutely no question. But because I come to this with the assumption that if you're looking for potential and that's represented, high potential is represented at relatively the same proportion in every racial group, then that tells me, the data tells me, that we're not reaching all the high potential students. When 50% of students in Texas are Latino and only 23% of UT students are, then something in that education system, or more likely many things in that education system from pre-kindergarten all the way through university, is not ensuring that the University of Texas is able to get all of the high potential students. And we've got to change the system to do that. And it is many different ways. It's not solely from an equal opportunity admissions program. It is also by making sure that we eliminate those inequities in kindergarten through 12th grade. It is also with making sure that university educations take account of that systemic flaw that at least to date has made it impossible to get all the high potential students from all racial groups.
Well, let me, first I'm a little, I'm not a friend of Rick Sanders, so I have met him. And I will tell you, I've talked to him, and the establishment who are the pro-preference establishment has viciously gone after Professor Sanders, who I can tell you from the very beginning of this, his first article, made clear he had no objection to using race preferences if they were. He has no principled opposition. This idea that he is out to get these policies is just, it's a slur, it's a slander, it's not true. What happened is he began to see what was happening at UCLA Law School, and it was troubling. And he was getting, and when you read the book, and I have not finished the book, I've started the book, but let me tell you a simple example, and you see it all the time, and his data is impeccable, and he lays it out there. If you take the same student with the same LSAT, the same GPA, and the student got a very large preference to get into the University of Michigan and decides to go to Michigan, but you took that same student and let's say you put her at Valparaiso, which would be a tier 2 or tier 3 law school. That student at Valparaiso will not get stuck feeling that she's in the bottom of the class. She won't have needed a preference to get in Valparaiso because her SATs and GPAs will have fit completely. She will go just like everyone else through her classes, won't lose interest in school, won't become discouraged because of the clear pattern that the students who get these preferences finish typically in the bottom decile of the class, so the bottom quartile for sure. She'll pass the bar. She'll pass the bar because she's prepared and she doesn't have, she's not discouraged about it. And Professor Sanders' work shows that while you may have fewer minority law students initially, you will actually have more minority lawyers passing the bar. Some of these students that go to these elite schools, it's not that they're not capable of, I mean, they could have gone to my law school was a tier 3 or 4 law school. You don't need race to get into my law school. But we have probably half the judges and half the lawyers, in the state of Minnesota, and they do, we all do just fine. We eke out a living and we do what we can. And so that was Rick Sanders' point, is that these policies aren't working. They're actually harming the beneficiaries. And so there was another point that Mr. Saenz made, and I wish I'm trying to think of it, but, the other thing, the suggestion that somehow, I will take issue, I'll just respectfully disagree with you on this. I think one of the worst things we can do, is bring in students, minority students, because we're looking at context, and then set up separate special study groups for minority students. Just looking at context. What message does that send? I mean, I don't think that minority students need special help. I think that they can compete just like everyone else. And when they get there, Michigan had there was a wonderful anecdote, and it's in the testimony of the trial. Several black students came to the Dean of Admissions. The Dean of Admissions was being deposed. And they came to him and they said, we understand that you may have admitted that you have this program here, this special admission program. They actually called it a special admissions program for a while. And they said to him, if you are admitting me under this special admissions program, I'm not coming to your school. You're going to either admit me because I belong here, or I'm not coming. And that's what everybody wants. Everybody wants the compliment of feeling like they belong. And I think, I don't disagree with Mr. Saenz and others who say, this is what we should be doing. I mean, it's kind of, I don't question the motivation, but I really think it's a terribly destructive thing. Set the standard, whatever it is. De-emphasize the SAT or the LSAT if you want to do it. I think it's a bad idea, but it's okay. Do it. But whatever the standard is, apply it equally to everyone, irrespective.
Okay, we have time for a couple more. Yes.
Mr. Saenz, I have a couple of questions for you. First question would be, you talk about numbers as far as in Texas, 50% of the population is Latino, and yet there's only...
50% students.
What, excuse me?
Students, public
Students.
schools.
Okay, my real question is then, that can also, I guess the better question is 50% of students. Sure, how many percent of students are actually applying to that school as opposed to going out and getting a job or going to the military? I think that 50% number can be slightly misleading. Well, my bigger question is, you want to talk about picking the best of the best regardless of race, correct? You want to have the best potential of the person, correct? In your last closing statement, you quite literally said that there was a difference between a white person and a black person in the same socioeconomic standing. You would pick the African American. Yet, typically, you say that the socioeconomic standing that creates the situations in schools that create unfair education opportunity, those same socioeconomic standards will apply to that person. And to preface this, I grew up in LA, in a very, very Latino community, a very, very, very Latino community, like 13 blocks from my home. It's not joking. And yet, I had the same socioeconomic standing as all the people around me. You say you pick my neighbor who had the same exact standing, the same exact hardship. But what you don't look at is the fact that inside that society, I was being considered a minority and was treated as such. That is a very real fact in that community. So you're saying that in that same community, you're going to pick the same person that happens to be black or Latino or however you want to put it, over the fact that I'm white. Yet, we have the exact same potential. But because that person is of a certain race, we're picking them above a person. In doing so, I believe that you contradict yourself immensely, and in doing so, I feel like you are actually being extremely derogatory towards people like myself.
Well, I'm sorry you feel that way. I certainly believe in a whole person evaluation. Your context, including the fact that you were an isolated, in an otherwise overwhelmingly a community of another race, is relevant context to consider. So I would think that would be considered in an admissions system that looks at everyone's potential as well. What I was saying to you, to everyone, is that because race still matters in our nation, part of the relevant context to consider is whether or not a 17-year-old, again, specific context should be taken into account, such as yours, but whether or not a 17-year-old grew up in a society where there is a negative perception of his or her race at majority levels, that ought to be one of the considerations in looking at a whole person evaluation. That's what I was saying. Now, as regards your first statement, again, my approach to this is that within all of the racial groups, high potential is equivalently represented. So that I don't accept that our education system, all the way through, is performing the way that it should if higher proportions of particular racial groups end up not going to college, but going to the military or going to jobs. Those are perfectly legitimate, but there should be the exact or similar proportions among all racial groups that do that. If there was unconstrained choices and unconstrained opportunities. But the fact that there are higher proportions, which is what you seem to accept, in, for example, the Latino community that are not going to college, I don't accept that that is a system that is picking all of the high potential students and putting them toward higher education. I think there's decision-making going on that is constrained because of limited opportunity. So again, if you start from the proposition that a public university's overall ultimate goal should be to get all of the high potential with higher education students into that system, then the system is failing regardless of where the disproportionate numbers of students from particular groups are going. It doesn't matter whether they're going to other colleges or taking other opportunities post-high school.
Well, I do briefly, I think that we should be looking for all the high potential students, wherever they are. I don't care who they are. And I don't think their skin color makes one bit of difference. If all of the high potential students next year were black, bring them in. If all the high potential students next year happen to be Hispanic, Latino, Latina, bring them in. If they're Asian, bring them in. That's what we should be striving for. Putting race aside and looking for the highest potential, irrespective of race. One brief comment. The poll, I forgot about this. I did see the same poll that Tom saw from the AP. I would ask you to take a very close look at what they were trying to accomplish there by suggesting that a majority of Americans maintain negative views of Black Americans or Hispanic Americans. I would just say I don't accept it. I just don't accept it. So.
We have time for one more short question and short answers.
This is just a comment real quickly. So, just from a psychology perspective, you stand up, anyone stands, and so we all stand without really considering current research, and we're reading research without fully considering value judgment, and without really considering the microaggression that goes on and is currently going on. And I think that's what Mr. Saenz is expressing. But we need to, especially, and so I encourage, most of you who are in law school to take a close look at psychology and what psychology is saying in regards to microaggression, because this context picture, the majority is, it's an important point to consider, and just, you guys are all making me nervous because I'm but the thing is to consider different perspectives. For instance, the psychological research that is coming out today in the state of 2012 and what they're saying about microaggression. And because race still matters, and it may not be explicit, but it's definitely implicit.
Can you just define for all of us who are not psychology people what microaggression is?
Yeah, microaggressions are basically everyday, like things like compliment. They can take it from a compliment, they can take it from a non-verbal messages, but essentially, whether intentionally or unintentionally, they all carry this connotation that one race is superior to the other, and that one ethnic or racial identity is better than the other, and thus, as when you speak to people and say you look at me and you might think, oh wow, this guy's probably from Mexico, he has such a good accent, you are in fact committing a microaggression. Because one, I am not from Mexico. 2, if you had assumed that I wouldn't speak good English because of the way that I look, you are committing a microaggression. So microaggression are essentially, in short, everyday slurs, comments, remarks that sometimes people, well-intentioned or not well-intentioned, give to others as a compliment, but in fact they carry a really negative connotation. When people are continuously exposed to microaggressions, like we see in the media, like we see in everyday interactions, it has a negative mental health effect on the person. So when you go to a university environment and I step into this classroom and I see that I'm one of the only few Latinos, why do I feel that I belong here, even if I'm qualified to do so? So there's a lot of these little things that go on, they start getting into your mind that as a white person, sometimes you may not see it if you're in a majority setting.
Thank you for that. And I'm afraid we are out of time. So join me in thanking our